review orders. Of course, we have Article 50, which guarantees the right to have any dispute, and the word used there is any dispute, adjudicated by an independent and impartial court. So the drafters left nothing to chance. Article 159 provides for the principles to guide courts. Lastly, there is what I call the Great Command, or the recommandment, you may call it so, in Article 259. It prescribes in clear terms the manner in which we shall interpret the Constitution. That is, we shall do so in a manner that promotes the purposes, values, and principles of the Constitution, and also, among others, the development of the law and the rule of law. By now, it's beyond doubt that the access to courts and the right to be heard in a court of law as a serious constitutional underpinning. On the face of all these clear constitutional provisions which I've mentioned here, which dictate in clear terms the right to access justice, the question is whether or not the provisions of Order 53 and also Sections 8 and 9 of the Law Reform Act are still relevant. These provisions, as stated earlier, require in mandatory terms that a party seeking that a party seeks the court's leave to approach the court. Even when a party is seeking a remedy, like those, for example, under Article 23. Section 7 of the 6th Schedule to the Constitution provides, again in clear terms, that all existing laws, as at the date of the Constitution or the date of the promulgation of the Constitution, must be read with such adaptations, alterations, modifications, so as to conform with the Constitution. I have several stated that time has come for Parliament to relook at the provisions of Order 53 and Sections 8 and 9 of the Law Reform Act and determine whether they can be brought in line with the Constitution as far as access to justice is concerned. I'm fully aware of Section 12 of the Fair Administrative Action Act, which imports judicial review principles to the Act. I'm also aware that no matter how beautiful these common law principles are, they must conform with the Constitution. Back to the traditional common law requirements of leave, the purpose of leave was simply to filter vexatious or frivolous proceedings. At the leave stage, the threshold is very low. All that the litigant is required to do is to establish an arguable case. This is the first stage, the litmus test to satisfy. After the leave is granted, the threshold is much higher. In my view, all the parties in this court jumped to the final stage after leave is granted and argued as if they were attacking the main motion. It has been argued that the suit, it has been argued that there are 2 petitions pending before the court. This was admitted by all the parties, but at this stage, if the leave is granted, once the substantive motion is filed, a party can make an application or can apply to the court either to stay the proceedings under Section 6 of the Civil Procedure Act, or even apply to consolidate, whichever options are available. It has been concluded that the applicant has not exhausted the available remedy. That may be so. True, this is a dispositive argument, especially considering the provisions of Section 8 and 9 of the Fair Administrative Action Act. However, at this stage, it's safe to argue that such an assault can be launched after the main motion is filed. In a nutshell, the grounds in the PO can be raised in response to the substantive motion once it's filed. I find backing in the Constitution, in the provisions I've discussed earlier, on the right for a party to approach the court, and also the right for a party to have any dispute are determined by a court of law as provided for under Article 50. It's safe at this stage to record the words of Madam Chief Justice that as far as possible, courts should hear and determine disputes or hear and determine cases on merits. In other words, courts should be slow to dismiss cases without hearing the parties. Though Chief Justice Madan died many years before the 2010 Constitution, his wisdom and spirit is discernible in the class of rights in Articles 47 and 50 of the Constitution. In fact, one may be forgiven for thinking that his spirit was present during the constitutional making process, because most of the things he said through his judicial pronouncements can be discerned from the Constitution. In conclusion, I find it hard to close the door of justice to a litigant. I have already cited the articles of the Constitution, that is 22, 23, 47, 48, and 50 of the Constitution. I need not repeat them here. Rather, I will recall the words of the President of the Constitutional Court of Lithuania, who, describing the nature of transformative constitutions such as ours, stated that the doors of justice are as open as the Ritz Hotel. I do not see how I can comfortably close such a door using common law principles. In the end, I opt to hoist high the constitutional dictates. That is, I opt to hoist high the dictates of the Constitution and uphold the right to access the court. I therefore grant the applicant leave a sort and direct that the substantive motion be filed and served before the close of business tomorrow, that is 24th of April. Thereafter, parties will be at liberty to decide the next course of action, whether to apply to stay the proceedings, that's an option, for example, or consolidate with the other petitions as they may deem fit, or decide how to proceed. As for the stay, no serious argument was presented before me to warrant the grant of the stay. In any event, the nature of the process under challenge, it will be in the interest of fairness to allow the process to proceed without disrupting the stay. So I'm not persuaded whether there are any grounds for stay. So those are the orders we have had, and sorry, and thank you for your